Hello and welcome to this webinar to launch BankTrack's latest human rights benchmark report. Thank you for joining us. We're going to wait a few minutes while people arrive before beginning. Hello again, everyone who's joining. Thank you very much for joining us. We're going to wait till 1 or 2 minutes past before we kick off. Thanks again, everyone who's joining us. I think perhaps there might be some more people joining, but we'll get started with just some housekeeping matters to begin. So we're using Zoom's webinar function. That means you'll only see and hear our speakers on this call, but you can raise questions at any time using the Q&A function. We've had over 325 attendees register for this webinar, which is a frankly outstanding number for us. Thank you very much for this huge level of interest. We're sure this is in no small part down to the great lineup of speakers that we have today. We don't expect everyone to join, but we are recording the webinar. And we will send a link to the recording to everyone that registered. And just to let you know what kind of company we're in, we have attendees from the banking sector, including banks that we've benchmarked, as well as banks that we haven't benchmarked. We have investor attendees. We have many attendees from civil society, from intergovernmental organizations, and we have people who registered with their personal addresses. We have no idea who you are, but you're all very welcome. As I say, using the Q&A function, you can post questions either in your own name or anonymously. We might talk about some individual banks' scores during the webinar, but the Q&A won't be the place to go into why a particular bank received one score rather than another score. We're happy to have those kinds of conversations, but ask that they happen on a one-on-one basis later. So to begin with, yes, welcome again to the launch webinar for BankTrack's latest human rights benchmarking report. Thank you all for joining us. On your screen, you should see the agenda for this webinar. We've got an hour and a half. We want to do something a bit different from what we've done in previous benchmark launch webinars that we've held, and make some time for discussion on the wider context in which we're releasing this benchmark, where banks are on human rights, and what we can do as a movement in the wider sense of the word to move forward bank practice on human rights. My name's Ryan Brightwell. I'm Deputy Director at BankTrack, and I lead our human rights campaign. I'm joining you from Nijmegen in the Netherlands. I'm joined by my colleague Giulia, who is the report's lead author and researcher, and by 4 expert panelists who I'm really looking forward to hearing from. At this point, can I ask you to briefly introduce yourselves, your name and your organization and your role, and where you're calling from, perhaps starting with Giulia and then our guests.
Yeah, thank you, Ryan. Also, you've already done a great job at introducing me. I'm Giulia Barbos, human rights campaigner and researcher at BankTrack, and I'm calling in from The Hague in the Netherlands.
Magdalena?
Hi everybody, my name is Magdalena Garcia Elorrio, and I work at UNEP-FI as a specialist in human rights and social issues with focus as well in decent work and labor rights. And I'm calling for Rome, Italy.
Thank you. Nadia?
Hi, I'm Nadia Bernaz. I'm an associate professor at Wageningen University in the law group in the Netherlands, and I'm calling from Houten in the Netherlands.
Thank you. And Emil?
Thank you. Hi, everyone. I'm Emil Sirén Gualinga. I'm calling in from Ecuador. I'm with the Quipa collective, which works to support indigenous peoples. And I'm also a member of the Quichua people of Ecuador. And in 2023, I wrote a due diligence toolkit for investors focused on indigenous rights. So that's the topic that I will be focusing on today.
Thank you. And last but not least, Ashleigh.
Thanks, Ryan. I'm Ashleigh Owens. I lead the work with financial institutions, that's investors, lenders, development finance, export credit, insurance, etc., at SHIFT, which is the leading center for expertise on the UN Guiding Principles. And I'm calling from the East Coast of the US.
Thanks all for joining us today. So to quickly introduce BankTrack, we describe ourselves as the tracking, campaigning and civil society support organization focused on private sector, commercial banks globally and the activities that they finance. We're based in the Netherlands, although we focus on banks globally, and we were founded in 2003. So 2025 is our 22nd year. And our mission is to challenge commercial banks globally to act urgently, decisively, and in a just manner on three overlapping and interrelated global challenges: the accelerating climate crisis, the ongoing destruction of nature, and the widespread violation of human rights. So accordingly, we divide our work and our team at BankTrack across three main campaign areas on climate, nature, and human rights. And the work of our human rights campaign includes the Human Rights Benchmarking Project, which is what we're mainly here to talk about today. And alongside this work, we also are involved in several other work streams in the human rights campaign, including campaigning and supporting communities fighting projects and companies with severe adverse impacts on human rights and the environment, which we call dodgy deals here at BankTrack. We have an extensive database of dodgy deals on our website, which you might be familiar with. And this is work that all three of our campaigns are involved in. Most of the time, these projects or companies have impacts across climate, nature, and human rights. We also have project work underway currently on banks and conflict zones. We're part of the B4 Ukraine coalition, and as part of that, we're campaigning for banks to fully exit Russia as the most appropriate response to its full-scale invasion of Ukraine. We're also a member of the Don't Buy Into Occupation coalition, tracking and campaigning on financial flows to companies that are supporting Israel's illegal settlement enterprise in occupied Palestinian territory. And we have an open complaint at the moment using the OECD guidelines National Contact Point System, the NCP system, regarding three banks managing equity investments in companies in the US private prisons industry, which are considered to be linked to serious human rights abuses, including forced labor and exploitation of detained migrants. We don't intend to go into detail on all of this work today, but this is just to give you a flavor of some of the work that we do in BankTrack alongside the human rights benchmark. And before I pass on to Giulia to present the results of the benchmark, a word on the history of our benchmarking project. Our first benchmark was a report launched in 2014 called Banking with Principles, launched just 3 years after the UN Guiding Principles on Business and Human Rights were unanimously endorsed by the Human Rights Council. And this was at a time when a group of banks had met the arrival of the UNGPs by discussing what the principles mean for the sector, for example, in the Tung Group, And these discussions were welcome, but we felt it was time to shift the focus from discussion to action and implementation. And so the first benchmark was released, and it covered 32 banks and included 12 criteria, which were all designed to very clearly ask, are banks doing what the UN guiding principles set out that they should be doing, what the UN guiding principles set out as responsibilities for all businesses. And 10 years later, this benchmark is on its 5th iteration, and it's been joined by 3 regional benchmarks for Africa, Asia, and Latin America, and by our human rights response tracking database, which we'll talk about more later, all of which we consider part of the Human Rights Benchmark project. So that's my sort of introductory remarks, and now I want to pass over to Giulia to present the results of the benchmark.
Hello, everyone. Can everyone see my screen? That's great. Okay, so yeah, thank you, Ryan, for the introduction. So in the next 20 minutes or so, I'll do my best to take you through some of the key findings. If you have any questions as I go through this presentation, please feel free to pop them into the Q&A, and Ryan will endeavor to address them as they come in. Let's now get started with presenting the results of our 2024 Global Human Rights Benchmark. So first, why are we doing this? So the UN Guiding Principles, or UNGPs, remain the world's leading standards for corporate respect for human rights. Yet, 13 years since their adoption, their uptake by business, including banks, has been slow. Given their vast networks of clients, suppliers, and investments, banks are uniquely positioned to influence respect for human rights. And the UN has made this clear and also reiterated the need for greater ambition and faster action from banks, as well as other business, to meet their human rights responsibilities. So since 2014, our benchmark has been basically pushing for banks to fully meet their responsibilities under the UNGPs. By assessing banks' progress and highlighting gaps, the goal is to drive stronger policies and better practices, accelerating progress to deliver better outcome for rights holders. So how do we do this? To assess progress, we look at 50 of the world's largest banks, focusing on commercial banking and balancing representation across different regions of the world. The benchmark evaluates these 50 banks based on 21 criteria, which are spread across 6 different categories. So these categories include 4 core categories, which look at banks' human rights policies, their processes for human rights due diligence, their reporting on human rights, and their approaches to remedy. These core categories are closely aligned with the wording of the UNGPs. And then based on the 15 criteria that make up these 4 core categories, we rank banks from laggards to leaders. This year, we added 3 new criteria in a 5th category, which examines the extent to which banks' policies specifically consider the protection of human rights defenders, the right of indigenous peoples to free, prior, and informed consent, and environmental rights as human rights. We also have a 6th category, assessing banks' responses to specific adverse human rights impacts raised by civil society groups and communities. And these are based on the database that we have on response tracking. Banks are scored on a scale of 0, 0.5, or 1 for each of these 21 criteria. And for the response tracking category, they are scored for each impact that was raised with them. So then these scores are averaged and kept separate. All the 50 banks in the scope of our benchmark are invited to review and comment on their preliminary scores. And then the final scores incorporate their feedback. And we also have an academic advisory panel of 3 business and human rights experts that help us resolve close scoring decisions. When we look at the big picture, firstly, it's clear that no bank is fully meeting their responsibilities under the UNGPs. So performance on average is very low, with the average bank scoring much less than half marks. But we see some gradual improvement over time. So in 2019, for example, the average score was 4 points out of 14. Then by 2022, that increased slightly to 5 points out of 14. And now in 2024, the average score for the corporate area has risen to 5.8. So we see that there is progress, but it is slow. While there are fewer banks in the lowest performing group of laggards, as you can see, many of the banks remain in the middle categories of moderate achievers and followers, with only a couple ranking as leaders with 11 points out of 15. I'll now move into presenting the main findings of each of the 6 categories, and I will start with the 4 core categories. You should be able to see, there we go, the policy slide. So policies are where we see the strongest performance from banks. Out of 50 banks, 42 have made public commitments to respect human rights, often referencing international standards such as the UNGPs or the Universal Declaration of Human Rights, for example. However, when it comes to extending these commitments to financing activities such as bond underwriting or asset management, only 30 banks make this connection clear. Another area where banks fall short is ensuring that their policies are approved at the highest level of business. So just 18 banks demonstrate that this happens. Moving on to the second category, due diligence, we are seeing some encouraging signs of progress here. So this year, out of 50 banks, 26 demonstrate that they have an ongoing human rights due diligence process covering all areas of their operations. So this includes lending, asset management, and bond underwriting. And this is a noticeable improvement from only 18 in 2022, which is when we did our last assessment. But we find that some major gaps persist when it comes to due diligence. So, for example, half of the banks fail to show that they meaningfully consult with affected groups as part of their due diligence process, or the consultation is even a consideration. And furthermore, tracking performance is another overlooked area of due diligence. Only 19 out of the 50 banks assessed, they don't assess if basically their actions to address human rights impacts are being effective. So that's also another gap. On a positive note, this year, for the first time in the history of our benchmark, we've had one bank, ABN AMRO, scoring a full score on meaningful consultation, showing how it integrates consultation across all of the areas of its business, including in its role as an investor, and referencing specifically that it engages with communities directly in certain circumstances. Also on this slide, we've included 2 other positive examples of Citi and Mizuho when it comes to tracking effectiveness, as they show that they do indeed track if the actions that they've taken to address identified impacts are helpful. And they also included indicators and stakeholder engagement to do so. So moving on to reporting, our third category, reporting remains one of the weakest areas of the benchmark. While out of 50 banks, 32 report minimally, such as, for example, they report on updating their human rights policies. Only 13 banks actually go further by reporting on their salient human rights risks in relation to different affected or potentially affected stakeholders, as well as different areas of business. and also detailing steps on how to address each of the impacts and risks they've identified. Only 17 banks provide concrete examples of impacts and actions they've taken to address them. Usually these are disclosed as case studies in sustainability reports or similar, rather than selected based on salience, for example. Another glaring issue is the lack of indicators. So out of 50 banks, 21 fail to disclose any qualitative or quantitative indicators for managing human rights risks. And 14 banks report just one indicator, which is far from sufficient. These are just a few examples of indicators used by banks that scored points on the benchmark. They're often, as you can see, topic specific, such as those addressing modern slavery risks or sexual harassment. When it comes to remedy, the benchmark's fourth category, there has been positive developments here, particularly when it comes to grievance mechanisms. So 6 banks now have developed or joined human rights grievance mechanisms, which are open to rights holders potentially affected by their findings, and are also backed by a clearly described process for handling complaints. Late last year, ABN AMRO launched its human rights remedy mechanism, and Deutsche Bank has made the grievance mechanism accessible to anyone impacted by its financing, going beyond the requirements of the German Supply Chain Act. We also have Japanese banks Mizuho and Mitsubishi UFJ have joined the JASER initiative, which provides a third-party grievance mechanism, which is grounded in the UNGPs. So these developments are really welcome. For example, in 2022, during our latest report, we only found 2 banks participating or having their own grievance mechanism. And another positive development is that more banks are now offering channels for third parties to raise human rights related issues. So, for example, we have participation in the Roundtable Sustainable Palm Oil Grievance Mechanism. Some banks are part of this. However, this grievance mechanism has a limited scope to that particular industry. And we also have examples of banks that are expanding existing whistleblowing channels, which were originally designed to address legal breaches like anti-money laundering issues, for example. They're expanding the scope so that these mechanisms are also able to receive complaints that are related to human rights. Despite these developments, remedy remains a significant gap. There is almost no evidence that banks are providing remedy or playing a role in remediation at all. So we only have found 4 banks scoring on our new criterion, which looks exactly for this, for evidence of remedy. Or were they supported with remediation using their leverage, and these examples are from the past 5 years. This highlights the need for stronger commitments from banks to support affected rights holders in seeking remedy for harms. We hope to find more examples in the future, and we also hope that the development of grievance mechanisms in the banking sector continues to expand. But we also find that there are some challenges. We've seen, for example, with existing grievance mechanisms, such as the one of ANZ's, complaints often get rejected due to a client's refusal to participate in the process. So this also underscores the need to improve accessibility so that rights holders can seek remedy, file their complaints, and to do so, seeking client consent is much needed. Now we move on to category 5, which is a new category for this year. on specific rights indicators, and this also highlights serious gaps in addressing vulnerable groups often impacted by banks' financing, such as human rights defenders and indigenous peoples. So while 33 banks out of 50 mention indigenous peoples' right to free, prior, and informed consent in their policies, none of them actually require clients or investees to provide evidence of having obtained FPIC when required. Additionally, we also found that out of 50 banks, 41 failed to acknowledge human rights defenders in their policies, showing a lack of understanding of their unique risks. A landmark 2022 UN resolution recognized the human rights to a clean, healthy, and sustainable environment, but we found that only 3 banks have acknowledged this or integrated environmental considerations into their due diligence processes. Our 6th and final category concerns response tracking. So we analyzed 229 instances where banks were approached by human rights or civil society organizations about human rights allegations and specific issues. And we found that banks responded publicly 60% of the time, but only 21% of those responses actually addressed the issues raised, and just 15% outlined any action taken in response to address those issues. Compared to our analysis in 2022, we see that there is a worrying downward trend in bank responses, which are becoming more sparse and less meaningful. And banks are increasingly also failing to outline even a single action to address the often urgent and serious issues brought to their attention. To give you a little bit more context, even banks that score well in other areas of the benchmark, like policy and due diligence, often fail on response tracking. And some of these bank scores, however, are based on only 1 or 2 instances in which they were approached for response. But this indeed highlights a disconnect between having policies in place and taking meaningful action to real-world issues, such as the ones that we've listed here on this slide, which are examples of what banks were contacted about. So you can find all of the responses that we've analyzed on our response tracking database, which so far includes 243 instances of banks being contacted on about 20 different human rights cases. The database is fully searchable and it's updated regularly, so we plan to update it again later this year. You can find the link here. And to recap, this slide shows a few findings that I've just run you through in summary to illustrate where banks are doing well and where there are some gaps. We've seen that most banks have a policy commitment to respect human rights, but that only half are consulting with stakeholders, and that grievance mechanism and remedy remain rare. Overall, none of the banks assessed fully implements the UNGPs. So actually 70% of the banks assessed scored less than half marks and ranked as laggards or followers. The highest score, as I already mentioned, was 11 points out of 15. Meaning that even the best performing banks are quite some way from meeting the responsibility in full. And in general, banks are still failing to put people at the center of their risk identification processes and aren't providing or supporting remediation when they need to. And I know that I kept you all wondering until the very end, but here's a snapshot of the top and lowest performing banks in the 2024 benchmark. You can, of course, dive deeper into the full results on our website, as well as in the report. Finally, we've also outlined some key actions banks must take to address critical gaps. So first, banks must actively seek their perspectives of potentially affected rights holders to make their human rights due diligence effective. These insights should also directly inform decision-making and investment practices. On reporting, we think it's important that banks work closely with their clients to address adverse impacts and also openly communicate their actions. This is central to the UNGP's approach and also shows that policy commitments are more than paper tigers and actually inform meaningful actions, driving real change. Banks also have a critical responsibility to protect indigenous peoples and human rights defenders who are often armed by companies and the projects that they finance. At a minimum, banks must explicitly acknowledge these groups' rights in their policies and meaningfully consult them during due diligence. Remedy, which often is referred to as the forgotten pillar of the UNGPs, requires banks to ensure that people affected by their financing have access to grievance mechanisms. While we've seen that some banks have developed their own grievance mechanisms, they've joined existing ones or implemented whistleblowing channels or similar, these must be explicitly accessible to all affected individuals. And in addition, banks must also adapt client contracts to prevent complaints from being rejected if a client refuses to engage. And it's also crucial that banks respond constructively to human rights allegations, as rights holders really deserve this. And banks also should engage transparently with lawmakers as due diligence regulations increase globally. Yeah, that was it. So thank you so much for listening to our presentation. I hope that it highlighted the importance of this work and in pushing banks to respect human rights. We plan to repeat this assessment in 2 to 3 years' time, but this is dependent on securing the necessary funding. If you have any further questions, you're welcome to raise them during the Q&A, or you can also contact us afterwards by email. So yeah, thank you again for listening, and I'll hand it back to Ryan to kick off the panel discussion.
Thanks so much, Giulia, for the presentation. And I want to emphasize, Giulia, can you stop sharing your screen? There we go. Great, thanks. I also want to emphasize that producing this benchmark is the work of most of a year, beginning with reviewing the methodology and adjusting it, consulting on that methodology, drafting scores sort of in the springtime, asking for bank feedback over the summer, analyzing that bank feedback. Somebody already asked in the Q&A about the level of response that we'd had from banks. Throughout this process, we've had responses around the 50% level. This time we heard from 39 banks out of 50, of whom 5 of them acknowledged receipt and didn't have further comments, but the remaining 34 had sometimes usually very extensive feedback which needed to be analysed, and finally writing the report. And for much of this time, I was away, so Giulia was leading this process by herself. So thanks to Giulia for delivering this report, and to everyone who was involved in the report, as well as to our designer, Raymond, who's designed the beautiful image, which is forming the background to our slides. And just to emphasize, there's much more detail in the report than we can summarize in a 20-minute presentation. So I do encourage you to jump into the the PDF and explore the findings further. So we've now got around half an hour for a panel discussion with our four expert guest speakers who we're lucky to have with us today. And after that, we will go into the Q&A. Many of you have been posting questions in the Q&A. I've been trying to answer a few of those while Giulia has presented, and some of them we will leave until after the panel discussion. So to start with the panel discussion, I want to begin with you, Nadia, if that's all right. I want to start with you, particularly as you've been involved as a member of our independent academic advisory panel, as we grandly call it, for this report, and as a panel member and as somebody with extensive experience in the field of business and human rights, I wanted to ask if you could share your reflections on the report's process, how you see the value of the benchmark, and any sort of gaps or areas where you think we need to, a report like this can explore further in future.
Thank you very much, and thank you for having me. First, I really want to congratulate you on this fantastic work. I have, of course, looked at the report before this, but yeah, this is really an incredible amount of work that you have produced. And it's really legible. I think that's the first thing that I would say as someone who's not very good with numbers. This is extremely legible and very easy to engage with. And I was actually going to make a comment also about the design and how nice it is to look at. And those things are important when you try to engage people, to make it accessible, using these colors and this particular design. This is important. It's not just about the numbers. So really congratulations on all of that. So for me, the value of this is it's very important, right? It's essential. It's essential work together with the other things that you do in the human rights area that you have talked about in the presentation. But by breaking down the UN guiding principles in those smaller elements and actually rating them, you really bring that text to life in a way. I think when the UN guiding principles were adopted, this was the hope, right? That initiatives like that would spring and that it would be used and it would be brought to life. Now, of course, that's not the only and that's good. It's not the only. You're not the only organization who has taken this on board and has done this wonderful work with it, but this is really very important, to do this work, not principle by principle, but almost. I mean, you've explained your 21 categories, and this is just very impressive. And of course, the value, I suppose, for other civil society organizations, governments, but also speaking as an academic, the value is in the comparison, of course, the comparison between institutions, but also the comparison over time, which you very usefully also presented, which I'd like to think shows a picture that is improving. So it's actually really nice to see. Now we can discuss of course, the details, but this is very important. And you've said, you've done this work for many years, and to have those numbers move over time and to be able to compare is very, very important. Yes, what else did you ask?
Well, thanks for the kind words. I mean, I think the last part of the question was so where an initiative like this could go in the future, what it sort of doesn't explore that could be explored more fully.
Yes. Okay. Yeah. The gaps maybe or something. So, I mean, this is very there is an evident gap, I suppose, in this initiative that I know other panelists will probably get into as well, which is that this, for obvious reasons, is based on publicly available documents. And of course, you've explained in the methodology that you follow up with banks individually, and you do this, you know, God's work, I would say, and, you know, patiently following up with all the banks and asking questions, etc. So it's not just about public documents. There is this sort of one-to-one relationship as well, where you discuss, but at the end of the day, it is about publicly disclosing what they do with regards to the UNGPs. Yeah, I mean, this is sort of the heart. And so there is always this debate, right? In academic work on transparency initiatives like this, it's also a very common issue, right? So do these institutions do what they say, but do they perhaps do better than what they say and don't report on it for various reasons that maybe we can discuss later in this panel? But for me, there's always this question, right? How do we address that sort of dilemma of having to rely on public information? And of course, disclosure is an important part of the UN guiding principles. It is about communicating what you do and tracking and communicating again your progress or not progress. So this is very important. But what does that tell us about action is, I think, an open question that we can start discussing. Discussing today. And in a way, this is also clear in the results, because banks, as well as other institutions, tend to do better on policy, because then it's about explaining what you do and writing it down and nicely. But when it comes to the hardcore action, for example, disclosing information about remedying processes that they've been involved in, there it's more difficult to get actual concrete results. And then the institutions tend to score lower because they don't communicate. And we then assume they don't do anything. So there's this that I see as potentially a gap and something that you could continue thinking of. I don't have the answer to this, but yes, I think it's more than a starting point what you do. Like, it is already extremely valuable despite that.
Thank you. Yes, of course, it's something we think a lot about. There's a lot to cover, so I want to move on with a second question for you, which is about the Corporate Sustainability Due Diligence Directive in the EU, the CSDDD. As many of us know it well, you've been following processes around in the EU closely in your work at the law group, and I wanted to ask you if you can share your insights on how you think some of the gaps identified in this report might be addressed by mandatory due diligence legislation, whether it's in the EU specifically or more broadly, noting we have a global audience for this webinar. Thank you.
Yes, thanks. I mean, I think the obvious thing to say is that the Sustainability Due Diligence Directive is asking companies, including banks, to do and not just to talk, right? So I think this addresses sort of what I've highlighted here about action versus words, right? So we're at the heart of this. The main challenge, of course, with due diligence processes, whether it is based on the UN guiding principles or based on hard law like the directive is trying to establish, the challenge is monitoring. Yeah, how do we know what companies do? And I think if you work closely with companies, you will know, because then you're privy to these conversations. But the monitoring at this moment is largely left to you, civil society organizations, journalists, to some extent academics. And I think here, I suppose the added value of the directive is that it establishes a a monitoring authority that is public. That each country in the EU will have to have a public authority, a public institution that monitors how companies are doing with their due diligence processes. That will be very important for you, I think, for your work to follow up those discussions in 27 member states. That will be a challenge. But to see how they approach this, how they try to go past publicly available documents. And I think they will need also your help in figuring this out in the future, because this will be all very new for most countries.
Yeah, indeed, it'll be interesting to see how that information can be used in practice. And we welcome the additional information for, you know, to help us in that monitoring job. I'm going to pass over to Giulia now to ask some further questions of our next panelist. Thank you.
Thank you, Ryan. So yeah, let's move over to Ashleigh. Ashleigh, I was wondering if you could tell us a bit more about what you think is needed for banks and as well as other financial institutions to close the remedy gap. As we've seen and found in our benchmark, that is still an area where progress is slow. We don't have many examples of banks with grievance mechanisms, although that number is increasing. So I just wanted to have your insight on this question.
Great, thank you so much, and it's a pleasure to be here. I think remedy was one of a few gaps for banks, right? And to step back for a moment, I think we are all cognizant of some of these gaps, and there are interesting NCP cases and civil society campaigns around some of them. I could mention bonds underwriting, lending to sovereigns, right? Bank relationships with NGOs, and that balance between carving them out completely from due diligence versus too much de-risking, bank advisory services, nominee shareholdings. Index funds will be the final frontier for 2025, I think. So how banks are approaching those areas in their due diligence. And then indeed, as you say, remedy is another place where we are going to see some really interesting movement, and we already are. I think you highlighted some of the new initiatives that have been put together by some of the financial institutions, whether that is on their own, right, or whether that is as part of a collaborative remedy process like JASA, the Japanese company's involvement in that. The other thing I think that's really important to mention when we talk about remedy is that remedy is more than grievance mechanisms on their own. And I think you've highlighted there Nadia's commitment to remedy more broadly. I think we're seeing that increasingly with financial institutions. And Giulia, you said, you know, talking about the role of banks to play a role in remedy. And I think that's really important, because under the guiding principles, as we all know, if a financial institution is contributing to an impact, it must provide remedy. For those more familiar with CSDDD, that would be something like cause jointly, right? Causing jointly. But we still have a role for banks to play when it is connected to impacts in its portfolio, but there isn't a kind of a facilitation or incentivization of that harm. It's just part of the massive portfolios that they're managing, that there's a need for remedy there. And we've seen some interesting developments around this concept of enabling remedy, the role that banks play in enabling remedy. And so this is a GPs. This is born out of the implementation of the GPs. It has found its way into some, you know, interesting tools. I really encourage those that are interested in learning more about enabling remedy to look at the Equator Principles Association tools to enhance access to grievance mechanisms and enable remedy. You've got really concrete tools available that help banks to start to close that gap. And that's all predicated on the understanding that banks are operating in this ecosystem, and that there are various judicial and non-judicial avenues that are or ought to be available to affected people that often aren't. And so what role banks have to play in strengthening that ecosystem and understanding upfront in client relationship, onboarding and transaction due diligence, the extent to which remedy is being prepared for, right? There are certain high-risk transactions where we need to be looking upfront about what remedy might be available to impacted people. We hope that it doesn't become necessary. We appreciate that it often does. And so working to strengthen that ecosystem, use influence with clients, map it, understand it, and influence in order to play that very important role.
Thank you, Ashleigh. I think you make a very important point about the remedy ecosystem and, using leverage and not necessarily just having a grievance mechanism in place. This is not equal remedy, but really doing collaborating with others, engaging with clients, and finding also other ways to play a role. I'd now like to ask you a second question. So I wanted to ask you about other gaps that we find in our benchmark. We find that there is a troubling absence of bank safeguards to protect human rights defenders and indigenous peoples, for example. So I was wondering, based on your experience working closely with financial institutions, what do you see are the main challenges for banks in enhancing the respect for these groups' rights?
Sure. Very big topics. I'll start with human rights defenders. There have been reports, and I think we're all very cognizant of the fact that civic space in which human rights defenders can operate, can protest, can raise issues, that space is shrinking across the globe. This is very, very important for banks because a lot of the data that is flowing into banks, perhaps via, data providers, et cetera, is reliant upon articles, campaigns that are covering the activities of human rights defenders. And so to the extent that that civic space becomes restricted, we don't get that information in. Right. And of course, all of us understand that risk management and due diligence is better done in a proactive rather than a reactive way. Right. And that early information about where there are issues in the portfolio is so critical for financial institutions. So we need to be looking more carefully about how banks can understand and work to increase that civic space and not be, for example, ignoring situations where clients are suing human rights defenders and closing that civic space that we all need to be operating. I think there can be a trust deficit between banks and rights defenders, particularly those sort of proxy stakeholders that come and speak to banks. It can be hard for banks to be comfortable to talk about particular cases. It can be downright impossible in some cases. But that doesn't mean there can't be a dialogue with defenders about processes, about approach, and getting sort of concrete ideas on existing and innovative approaches through constructive exchanges with civil society. We always say to the banks that we work with that these relationships are best built in times of peace. Meaning that when a bank is undertaking its salience exercise, its double materiality assessment under the CSRD, which are the same thing, those proactive conversations with defenders and civil society to say, what would you see us do more on? What do you think is really important for us to be working on? Where are the hotspots as you see them? We'd like to do more. We can't promise we can solve it overnight, but we want to build that constructive relationship. I've seen that happen very, very well. I've seen it go badly wrong, right? And it often comes down to that, creating that relationship of trust. Of course, at the moment, another challenge on the defender side is the politics and banks sort of fearing to take a side in political contexts. By speaking to X or Y individual or group, does it look like we're aligning ourselves with a particular position? Shift runs an FI circle where we have 13 banks that come along. It talk about pre-competitive challenges. We talked about human rights defenders, actually, and shared some of those challenges and early opportunities. And we had a real economy company come along and explain to banks how they deal with this issue in some very challenging jurisdictions. And essentially that real economy company said, we have a very public and strong position that if someone wants to talk to us, we will talk to them. And so when we get pushback from governments or other stakeholders to say, why are you entertaining this individual and this extreme point of view or what have you, they say it's our policy to have those conversations. We get that information in and it's good for all of us. So that was something that I think really struck the banks that we work with and is something that could be replicated. Last thing on defenders, I would say is of course, getting the right information in from clients can be very, very tricky. Here we want to see more from banks, the engagement with country-based personnel or practitioners, right, within client organizations whenever possible, rather than being satisfied with those simple answers from IR or corporate affairs. And finally, really encouraging clients to develop policy commitments and internal approaches for respecting human rights defenders. These are expectations for higher risk clients that we can set as banks to say, well, in this context, it would be good to understand what is your policy, what is your approach when it comes to civic space and human rights defenders. Giulia, on Indigenous peoples, that's another really big topic. So I'll try not to go into too much detail and just give some headlines. But I think one of the things we talk about with our banks at Shift, and in fact, we have publicly available publication on FPIC that everyone is welcome to look at, challenges for banks on FPIC. How to navigate differing views on whether a community is Indigenous, how to determine what good FPIC processes look like is something that can be tricky. But there are really great steps being taken, including, where equity participation is a proxy for FPIC. If a client is really serious about partnership and equity participation of Indigenous groups, that's a really great sign that there may be consent there. Poor quality and limited information on Indigenous peoples by clients. We talk a bit in that paper about the strategies that banks can look into to try to get more good quality information from their clients. And of course, as the previous panelist said, as we get better disclosure from our clients, as we get better disclosure incentivized by the CSRD, incentivized by other reporting initiatives, benchmarks, et cetera, banks will be able to access that information so much more. And then finally, financial institutions being better able to spot and address where there are significant power balances between their clients and Indigenous peoples, and really get into that in some of the enhanced due diligence and some of the engagement, and not take these assurances at face value that everything is fine and no need to look further here.
Thank you, Ashleigh. And I think what you've just discussed about Indigenous peoples, we can continue by moving on to Emil. So I'll pass it to Ryan for his questions.
Thanks. Yes, indeed, Emil. Great that you can join us today. You've been working closely on the financial sector's responsibilities, specifically with regard to Indigenous people. For some time, and as you talked about, you worked with Amazon Watch on the Respecting Indigenous Rights, was termed an actionable toolkit for institutional investors, which includes advice for the banking sector. I wanted to ask you first of all to talk a bit about why in your experience it's so crucial for banks to strengthen respect for Indigenous people's rights. In particular, as well as whether you see examples of good practice in this space, or whether banks are largely, in your experience, falling short.
Thank you, Ryan. So why it's important, I would say, because in many sectors, especially those sectors that are connected to lands, Indigenous peoples are disproportionately affected by corporate activities that do not respect their rights. So, for example, Indigenous peoples represent 6% of the world's population, but are affected in over 34% of conflicts over extractive and industrial activities. As well as, for example, in 2021, over 40% of assassinated environmental defenders were Indigenous. And the sectors that are affecting Indigenous peoples mostly are the mining sector, oil and gas, agribusiness, and renewables, but also increasingly carbon offsetting projects, and as well as biodiversity offsetting projects and the infrastructure projects. Also, why it's important, I think often there's this attempt to try to create a business case for why banks should care in terms of reputational risks and so forth. I could give you many examples of negative reputational impacts, such as in the case of the Dakota Access Pipeline. But I think it's time that we move on from the business case, because we shouldn't have to create a business case for our rights and dignity to be respected, and indigenous peoples, human rights defenders not to be attacked, persecuted, and often even assassinated. So I think it's a matter of basic human dignity. And to answer your question whether banks are doing enough, if banks had advocate policies on indigenous rights, we would see less land grabbing, persecution, militarization, and attacks of indigenous peoples, human rights defenders. So I would say banks are not doing enough.
Thank you. I think that's a really important point about the business case and the need to move on from it. I think what do you think are the most important practical steps that that banks can take, beyond developing a policy, for example, putting in practice to ensure that they're effectively respecting indigenous people's rights?
So as your benchmark has found, many banks are mentioning policies, but the question is, how do they effectively ensure that the respect is translated on the ground? And there's two main standards that the banking sector uses. One is the International Finance Corporation Performance Standard 7, as well as the Equator Principles. So many banks have a policy through which they expect clients to adhere to the IFC Performance Standard 7. But the question is, how do they implement this in practice? And as we have seen, it's not translating to the ground, even if the policies are there. Another limitation is that some banks have stronger language on FPIC, such as we will not knowingly provide financial services to, but only for certain sectors, such as agricultural commodities. As well as banks that are signatories to the Equator Principles, but this is limited to project finance, so it does not apply to the general corporate finance, which is also a limitation. And the Equator Principles have been criticized by indigenous people's rights organizations for their weak and non-committal language to indigenous people's rights. So with this context, the practical steps that banks can take, well, one limitation that I see is that when communities complain to banks, a common response is that they cannot comment on individual clients. So there is a need for a policy to require consent to disclose client relationships. And this should be part of standard contracts of banks in loan covenants. Also, instead of expecting clients to respect it, they should have a policy to require it, and require that they disclose respect for free, prior, and informed consent. This needs to apply across all sectors and all financial services, and not limited to, for example, the agricultural commodities. Banks should also acknowledge that it's difficult to find cases of companies respecting indigenous people's rights. So the assumption must be that, with very few exceptions, projects affecting indigenous peoples do not have FPIC, because it's difficult statistically to find those projects that can show that they comply with international human rights law regarding FPIC, independent impact assessments, compensation, and benefit sharing. So also this needs to be independently verified and consulted with communities, rather than relying on self-disclosure, because there is a conflict of interest. Companies will not say we don't have FPIC. I mean, that wouldn't make sense for companies to disclose it, because it would affect their finances and so on. I would also like to disagree with the previous comment that equity participation is a proxy to FPIC. It's just a commercial relationship, and it doesn't say anything about the process of free, prior, and informed consent, and whether this led to consent. I would also urge banks to develop standard contracts for loan covenants to be developed in consultation with clients. No, not clients, with indigenous peoples, as well as indigenous peoples' rights organizations, that allow banks to exert leverage over clients throughout the lending cycle, as well as afterwards. So for example, the Equator Principles, they have guidance for incorporating social considerations into loan agreements, but the language in this guidance is too weak on indigenous rights. So for example, what the banks could do is that they could have clauses for precedent conditions that require for a contract to be valid and enter into force that the company will provide evidence that FPIC has obtained, or as well as warranties and representation, which require a statement by the client that it has no litigation or complaints by indigenous peoples and communities, that it will comply with international human rights law, national law, as well as indigenous people's own laws, protocols, and justice systems. Undertakings, the client should agree to disclose any complaint or adverse impact, and not to proceed without free, prior, and informed consent. So I think banks that are serious about the human rights commitment should develop these policies in consultation with indigenous peoples, and this could set an important precedent for other banks to follow. Because for many indigenous peoples, those projects that are financed by banks are destroying their cultures and ways of life. And the people that are defending those rights are facing reprisals such as threats, attacks, persecution, criminalization, and assassinations. So I think although banks say that it's challenging to implement the policies, I think it's time that banks stop coming up with excuses and instead take action to stop the devastation of indigenous people's lands and territories. Thank you.
Thanks so much, Emil. I think you've covered a lot there. And there's a lot of overlap here with other areas where we're seeing gaps. The point that you made about client consent is to being able to disclose relationships with particular clients, which we see good practice, and we know that it can be done, but it is limited, and that can help push forward on indigenous people's rights, but also effectiveness of grievance mechanisms, for example. So many parts of this agenda are reliant on transparency. I want to pass back over to Giulia
Thank you, Ryan.
Questions.
Yeah, we'll move on to Magdalena, last but not least, and we'll change topic as well. Magdalena, I was wondering if you could reflect on some of the findings of our benchmark that indicate that there are significant gaps in the levels of accountability and transparency in the banking sector, as well as when it comes to disclosing indicators about impacts, for example, and how these are assessed and addressed. Especially based on your work and with the upcoming publication of UNEP-FI's Human Rights Toolkit. What is your insight? How can banks improve in addressing some of these gaps that are remaining?
Thanks, Giulia, for the question. Yes, definitely the toolkit we are launching next week. I mean, the idea is tailored to support banks in implementing the UNGPs, and of course can be used to improve and better meet the accountability and transparency expectations for the financial sector. So based on this toolkit approach that we receive a lot of inputs for many organizations working in the human rights and business, and specifically in the financial sector space. Based on this work, there are two aspects that I think that are very important to highlight in order to improve the quality and the adequacy of these reports. First point is related to the sufficiency of the information provided by financial institutions on the actions that they are undertaking. And here we think that there is important to refer that in the level of institutional efforts in terms of processes and policies, they report that they have in place, such as, for example, human rights due diligence, human rights due diligence processes, policies, grievance mechanisms, etc. We think that there is a need to avoid general statements on these efforts. There is a need really to go directly explain or inform how these processes and mechanisms and policies can directly be linked to a specific salient human rights issues. So This is one point we see that it could improve this reporting. The second point is trying to include examples of actions in the financial level. We are not seeing much on that. For example, on client engagement, are how banks are engaging and how banks are prioritizing engagement with clients in a specific human rights issues. Are they providing technical support? Are they raising awareness? Are they developing joint mitigation plans? Sorry, are they setting contractual clauses? I think that there is a lot of room to banks to report on these specific actions in the financial level and not so much in the institutional level. So the second point I think that is important is how they can incorporate in an explicit way indicators, as you mentioned. I mean, there is a lot of need of metrics and to showcase and to support how banks are measuring their performance and monitoring the progress and the outcomes of this action. So in the toolkit you refer, we are we are setting which are like the key considerations financial institutions need to take into account in order to develop strong indicators in different levels. And we are providing some examples of indicators in the policy, in the policy implementation, portfolio management, and risk assessment. Of course, there are examples, we need to continue improving and working. And on this, we got a lot of support on comments that on Shift, because Shift, our colleagues have been working on this great publication of the developing the S and indicators of in this regard in social issues. So we use a lot on that. So 3 considerations I want to share on this. First, the importance of developing indicators that offer insight into the quality of the financial institutions respond to risk. For example, we need more to know, not so much knowing, for example, the number of financial operations where human rights violations was implemented. We need to know the number of human rights processes where meaningful engagement with affected communities, for example, was considered. So trying to move forward in this kind of quality level. And then, for example, the importance of using indicators that show the top management commitment with human rights issues, because since we can have many indicators in the operational level, but if we cannot show that there is this commitment, for example, senior level bodies that have oversight and responsibilities in human rights, it's quite a signal to show that. And finally, the importance of using indicators, maybe quality indicators, to explain why and how some decisions are taken internally in the financial institutions, for example, in the how the severe impacts are being chosen in terms of the criteria that is being using, and this is also very helpful to understand that. So this is a bit of our reflections in these levels of actions and indicators.
Thank you, Magdalena. I think that's very helpful to hear from you, and especially this advice, the 3 main advice on developing meaningful indicators. We find that that's an area where we get a lot of questions from banks, or where there seems not to be a lot of guidance out there on what a meaningful indicator on human rights is. And also good to discuss, how can we make reporting, improve reporting, and how steps that banks can take to do so. Lastly, I want just to ask you a question, given that this is the last question to you. What do you think are the steps that can help drive meaningful progress from here in the banking sector? Is there something that can speed up the implementation of the UNGPs?
Thanks, Giulia. I want to respond to that question considering the role that we can have, not only UNEP-FI, but other actors in the financial and human rights space. I understand the point my other colleague made on the business case and the need to move forward and really defending and protecting and respecting human rights. But I have to say that there is still a need for financial institutions to really build a solid business case for human rights. I have to say that there is a need, for example, for human rights and sustainability teams to develop this kind of strong business cases and to try to push internally with other teams, legal teams, risk teams, compliance teams, to really move forward the business and human rights agenda. So there is a need there to support these teams in order to have clear arguments on why these mechanisms, processes, and policies are needed. So we still see that there is a need on that side, and we can support on that. There is also the second step that I think that is important to push and this agenda forward and improvements is supporting banks on client engagement from a human rights perspective. I think that, as you mentioned in your introduction, the financial institutions have unique position to use and build leverage for the protection and respect of human rights, but they need guidance on how to really, and capacity building on how to deal with this in practice. They find there are a lot of challenges on this, so I think that there is room still to work on that. And as a third point, I would say that in regions where regulatory pressure are weaker or not so much present on that kind of driver, sectoral initiatives in the financial sector are also a strategy that we need to visualize, that we need to push to show that there are things that can be done. And we are seeing some examples, for example, in the constructive sector of banks trying to face some challenges in human rights and on this. And I think that there is a strong argument on the competitiveness of putting requirements on human rights in the financial sector. And with these initiatives, we can show that we can overcome this and we can really move forward. So finally, and my colleagues have also referred, there is also an interesting step on supporting banks and financial institutions on how to overcome legal barriers that they might feel that are legal barriers. For example, on setting certain mechanisms, they might, and this was mentioned by Emil, I think, they might think that they have some confidentiality issues related to the customer, relating to disclosing information on the commercial relationship. So if we really need to support them in trying to understand if this is really a challenge and how to solve the challenge. If not, we will still be having efforts from some teams and a pushback from the legal teams inside the bank, and we won't see any change that we are expecting. So I think that these are some, from a practical perspective, things that we can see and support in order to move a bit forward in the agenda.
Thank you, Magdalena. I think we've got about 12 minutes to go. We've run a little bit over time, but everyone's had such interesting things to say. I haven't wanted to cut people short. We have a few questions on the Q&A. We've answered many questions, hopefully to your satisfaction, and in message forms. But some of the questions that remain, there's sort of a two-part question from Sam Hummel here about the level of staffing that banks have on working on human rights due diligence in practice, and part of this is whether we evaluate it, and we don't evaluate this formally as part of the report, and part of this is what are the trends in the quantity and the quality in staffing levels from our interactions with banks, which is vital to ensure that these policies can be well implemented. So I think that's an interesting question to hear your reflections on. I want to read out a couple of questions so that you can, panelists, you pick the question you prefer to answer or share your reflections on the others. There's one also a good question about FPIC, and is FPIC as described under the IFC's Performance Standard 7? Is that enough? Do we need to move beyond that standard? Should another standard be used? Does that need improving? A good question. I think perhaps there's also a question about the change in the US administration, which we're all mindful of, and its anti-ESG campaign. Will this result in North American banks rolling back some of their public disclosures? Part of that's a question for BankTrack, but I think there's a question there about is that a trend that we're likely to see? Are we expecting a backward step from human rights as we might have seen in banks stepping back from the Equator Principles, from the Net Zero Banking Alliance in 2024? Are we going to see that kind of trend in the human rights space as well? So I'll open the floor to whoever would like to jump in first.
Maybe then I can just speak a little bit about that staffing question. I think it's a really important one. More so the numbers, right? It's the capacity of folks internally within banks, and I'm sure that's what you're reflecting on there. There's a pure numbers game as well, but it's also about capacity. I think that's an interesting point. And another angle to this, of course, is the shifting in budgets and relative political capital within banks. That's been brought about by the codification of our space into regulation and legislation. And a lot of the sustainability people within banks that I speak to are navigating that challenge of the balance, tipping a little over into sort of compliance teams, right? Which is both a good and a challenging thing. And particularly in the context of double materiality assessments under the CSRD and really some sustainability practitioners struggling to get their voice heard in those processes, even where they've been undertaking salience processes for years, right? So making sure that we're all aware that there's 10 years of practice and that a lot of bank sustainability practitioners are aware of this and are participating in this, and that informs compliance activities. New actors within the bank are being brought in. Internal audit is now highly relevant. The need to upskill internal auditors. And where there are, gaps, which most banks have, when we're bringing in external advisors, making sure that those external advisors have the requisite capacity on the international standards and aren't approaching these pieces of legislation that expressly align with the international standards without that knowledge. I've also seen a lot of frustration from practitioners there, where some of the quality of advice that they're getting isn't as useful as it should be. I do sympathize with the point that the questioner was making about these shifts in kind of cutting heads and then adding more and what have you. And that is a real challenge. But I think that piece about internal collaboration, capacity building, and ensuring the voice of those with experience is heard is a really key issue.
Thanks. I wanted to ask Emil if you had reflections on that question about IFC Performance Standard 7.
So I think the IFC Performance Standard 7 is from 2012, and international human rights law has been evolving. So there's a lot of legal decisions, jurisprudence from for example, Inter-American Court of Human Rights, as well as UN treaty bodies that go beyond what's in the IFC Performance Standard, which includes protection of indigenous peoples' lands, territories, and resources, independent impact assessment, compensation, benefit sharing, effective participation in decision-making, as well as free, prior, and informed consent. But also, as far as the IFC Performance Standard, it also depends how financial institutions or banks are implementing it. because at which part of a process is the performance standard triggered? Because if a company only applies it at the stage where they're seeking financing from banks, then it's not FPIC, because FPIC should be ongoing and throughout all stages of a project. So if it's triggered when companies are seeking financing, then the decisions have already been made to proceed with a project, most likely. Companies also need to have their own policies to evaluate and verify whether projects or companies are in line with international human rights law, and not just depend on consultants that assess those projects. For example, in Kenya, in relation to the Lake Turkana wind power projects, consultants found that the project was compliant with the IFC performance standard, but the report didn't recognize the indigenous peoples as indigenous people. So they found that they were ethnic minorities and marginalized groups, which didn't require FPIC. So I think banks should develop their comprehensive policies in consultation with indigenous peoples, in consultation with indigenous peoples' rights organizations. Thank you.
Thanks. Good points for the forthcoming review of the IFC performance standards. And Nadia, did you want to reflect on, there was a question on are the current text-based reports written by banks useful? Do we need more comparable standard data sets?
Yes, I'd like to say something about that. I find that this is Britta Delmas' question. Thank you for it. I find that question very interesting. Is there value in having completely standardized data, or at least prescribing a certain way of reporting on these issues? This is also an old question, but I think very valuable. So first of all, this is assuming it's possible to prescribe that globally. It's probably not, but we could imagine a standard being, you know, some kind of template being so good that it just spreads, and you know, there is an uptake, and banks do it. And for me, as researchers, I have all sorts of questions about how this could work in practice. And the first one, of course, is who writes these templates? Because if you control the questions, then you already control the answers, and that's my first thought about it. The other thing is, I think we do have some examples of relatively standardized reporting coming out of the United Kingdom modern slavery reports under the Modern Slavery Act 2015. And there, although it's not prescribed, there are all these categories, and companies in the end use them, because also at the beginning they were completely lost. This started 10 years ago. Lots of work has been done since, but so there is this standardized reporting to an extent under the Modern Slavery Act, and I have personally found that extremely unuseful, because it just turns into this sort of standardized responses, and I'm not sure it encourages sort of genuine reflection on actions and operations. But that's my view, and of course I also see the value in having standards, but I think it's a dangerous path. I'm not sure I would advocate for it. I'm happy to hear other thoughts. I know there are other panelists with thoughts on that. Thanks for the question.
I can share some thoughts on, I was also reflecting a bit on that, on the standardized that Nadia mentioned, trying to think which option was better. And I agree with her point on that it could be from one way very good, because in one side I got Nadia's point on the dangers of doing it, but on one side what I think is that we really need to track how banks are progressing and evolving in the UNGP's implementation and the things that are reporting. And for that kind of analysis, when it's completely free, what banks can draft in their reports, this kind of tracking of evolution and progress is not so easy to make. So if you have like a clear standards of what it's needed to be report, this is, I think, easier. So from that perspective, I think that it could be a good contribution to have this. But that's a thought. But yeah, it's a very interesting question, and of course we need to continue reflecting on that.
Thanks very much. We're pretty much at time, and I think at this point, rather than run on, I think we could continue this discussion. But I think it's a good time to wrap up at this point, and I want to thank particularly our panelists for joining us and for your excellent contributions, and to Giulia for your presentation of the report. And to all of you who've joined. I hope it's been useful. As Giulia said, do feel free to send questions to us by email if you have burning questions that haven't been answered. And yeah, on that note, thank you very much for joining, and wish you a good rest of your day. Thanks very much.
Thank you.
Bye.
Thank you. Bye.
Thank you so much, Ryan and Giulia.
Thanks.